Hello, this educational video is brought to you by the Colorado HOA Information and Resource Center. The topic of this video presentation is the HOA board member's role and responsibilities. This involves many concepts and obligations that a board member must understand and abide by. The information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. So what is the role of an HOA board member? A board member's position will involve leadership and trust. Let's talk about that role. Effective leadership consists of a partnership between the board and management, each of which plays an essential role. Understanding and negotiating these shared and complex elements of leadership is essential to the association's success. The main role of the HOA's board of directors is to establish policy for the association. An HOA depends on effective leadership to have a successful association for the benefit of all its homeowners. Board members are in a position of trust to ensure that the association's resources are used for the benefit of the association. An organization's board leadership should consist of volunteers who are committed to the association and who demonstrate an understanding of the community being served. An effective HOA board should determine the mission and goals of the association, establish board and management policies and procedures, assure that financial resources are available, and actively monitor the association's allocation of those resources to effectively and efficiently operate the association for the betterment of all its owners. Managing the HOA. An HOA must make a determination of who will manage the association based on its needs and resources. Managing the HOA's day-to-day operations is a function that the HOA Board of Directors must decide on who will take on that responsibility. An HOA board can decide to self-manage their association, with the board members taking on those everyday responsibilities of operation. The board will have to take into consideration the time involved, since they are volunteers, the required skills necessary for certain tasks, the issues that their particular HOA encounters, and the cost savings of managing in-house. Boards do have the option of farming out certain segments of these day-to-day functions to independent professionals. In the alternative, the board can decide to hire a professional manager to handle and be responsible for the day-to-day operation of the association. The board is then responsible for supporting the functions of that manager, granting them sufficient authority and helping to ensure their success in managing the association. The HOA's hired professional manager also then has the responsibility of hiring additional vendors for the proper and efficient operation of the association. What is the responsibility of the board member? HOA board members have an obligation to maintain a number of fiduciary duties and responsibilities. Let's discuss those obligations. The duty of care is a legal obligation imposed on an individual requiring that they exercise a reasonable standard of care while performing any acts that could foreseeably harm others. A standard that is applied in these circumstances is the reasonable prudent person standard. The standard requires one to act with the same degree of care, knowledge, experience, fair-mindedness, and awareness of the law that the community would expect of a normal, reasonable person under the same set of circumstances. The duty of loyalty. The duty of loyalty is a term used to describe a fiduciary's loyalty to a corporation. In this case, the board member's loyalty to the association and its owners. A board member should not be placing their own personal interests above that of the association and its owners. The duty of confidentiality. This duty places a restriction on the accessibility and dissemination of information by the board members in the scope of their duties. The duty of confidentiality is essentially a duty not to speak about confidential board matters to non-board members or share any such board materials with non-board members unless authorized to do so. Due diligence of a board member. A board member has certain obligations in their position of representing the association, such as due diligence and reasonable care. Due diligence is the effort made by an ordinarily prudent or reasonable party to avoid harm to another party or themselves. Failure to make this effort is considered negligence. Generally, due diligence refers to the care a reasonable person should take before entering into an agreement or a transaction with another party. Due diligence is essentially a way of preventing unnecessary harm to either party involved in a transaction. Reasonable care. Members of an HOA board of directors should always exercise reasonable care in making board decisions. Board members should undergo the necessary proper research, investigation, and analysis concerning issues facing the association and hire skilled experts that they can rely upon in making those decisions that affect the association. Used as an authority for legal research, Black's Law Dictionary provides definitions for diligence and due diligence. In many instances, there has been more liability placed upon board members, which in turn means that board members need to be more responsible and need to seek out more information in their decision-making process. The failure to act as such can open the association up to possible liability. Conflict of interest. The HOA Center receives many inquiries and complaints concerning a board member's real or apparent conflict of interest when making decisions for the association. The concept of conflict of interest is addressed in Colorado law under the Colorado Common Interest Ownership Act, also known as Kiowa, in Section 3833.3, 310.5, and in the Colorado Revised Nonprofit Corporation Act in Section 7, 128, 501 of the Colorado Revised Statutes. A conflict of interest is defined in Black's Law Dictionary as a real or seeming incompatibility between one's private interests and one's fiduciary duties. For an HOA board member, this means that one should always exercise independence of judgment in exercising one's powers and in making decisions. Board members have a responsibility to recuse themselves from their responsibilities any time they have a problem keeping their fiduciary duty to the association and its members. They must always represent the best interests of the association. It is advisable to establish a set of board member rules when dealing with any possible conflict of interest issues that arise within the association, and how to properly handle those conflict issues at meetings and when voting on issues. Advisory board members. Oftentimes, an association must handle very complex or time-consuming matters where they may be tasked with issues that require specialized knowledge, expertise, and experience. At other times in the board decision-making process, it may be valuable to the board and community to understand the history and reasoning behind past board practices and decisions. Non-voting advisory board members may be an option. Advisory board members may be able to assist with providing that information, experience, and knowledge to the present board of directors. They could be utilized to handle a specialized project and act as a supporting role to the board. Some specialized areas of expertise and backgrounds could be in the areas of business, accounting, legal, insurance, management, construction, and real estate. Past board presidents could be very helpful explaining and filling in the history of the community. If you consider these types of board advisors, it is important to have written policies in place in the association's governing documents. Consider this type of advisor's purpose, membership, appointment, termination, orientation, attendance, duration, authority, restrictions, guidelines, conflict of interest issues, and ethical concerns. Discuss this advisor concept with legal counsel to make sure that it is workable with the association's declarations and bylaws. Board officer positions. Unless otherwise provided in the bylaws, a nonprofit HOA corporation shall have a president, a secretary, a treasurer, and such other officers as may be designated by the board of directors. An officer shall be an individual who is 18 years of age or older. The president heads up the board, supervises all of the business and affairs of the board, and acts as the spokesperson for the board of directors. The president also has authoritative direction to order actions in furtherance of the policies established by the board of directors. The vice president of an HOA acts in place of and with the authority of the president in those instances when the president is absent. Also, the board of directors can give the vice president additional duties to act on behalf of the association. The secretary maintains the minutes of the meetings of the association, as well as maintaining all of the association's records. Additionally, the secretary is responsible for keeping track of the HOA's activities to make sure the actions of the association are in accordance with its bylaws. It also keeps track of the board members' contact information in order to inform the board about meetings and updates on the organization, and provides access to association records by its owners. The treasurer is the custodian of the association's monies and keeps account of the receipts and disbursements in the association's books. Additionally, the treasurer is responsible for keeping track of the organization's financial condition, coordinating the HOA's budgetary process, providing annual financial reports, handling any audit review, and keeping the other officers and board members informed about the HOA's financials. This has been an educational presentation from the HOA Information and Resource Center. Following this presentation, you will find a short quiz and some HOA resources. Thank you for watching.